Next up is invasion of privacy. The law recognizes that everyone has, under certain circumstances, a legal right to simply be left alone. It provides that there are certain subjects, certain places, and certain actions that are nobody else's business. On the other side, however, the law also recognizes that at some point a person's right to privacy gives way. For example, many things that people do significantly affect others, and the public, often by way of the press, has a right or a need to know about them. In the parlance of journalism, such information is said to be newsworthy. Invasion of privacy law is all about balancing these two sometimes competing interests. While the law can vary by state, courts have generally recognized 4 different types of invasion of privacy: public disclosure of private and embarrassing facts, intrusion, false light, and misappropriation. We'll cover each briefly. The first, and for student media probably most important and common category of invasion of privacy, is the public disclosure of private and embarrassing facts. The title actually describes the problem accurately. This type of invasion of privacy occurs when you publish information about someone that is so private, so embarrassing, and so intimate that a reasonable person would be shocked that you actually published it. The danger here is that, unlike libel, it is no defense that the information is true. Rather, it is simply that you cross the line in publishing it. The good news is that this is usually the type of information that should set off some alarm bells prior to publication. For example, providing graphic details about a person's private sex life, disclosing that an otherwise private person has a medical condition that they've yet to make public, or publishing detailed information about a person's grades when there is no good or newsworthy reason for doing so would be examples of this type of invasion of privacy. On the other hand, information that is just mildly embarrassing or that is already fairly well known is insufficient to support a private facts claim. The primary defense to this kind of invasion of privacy claim is newsworthiness. If information is truly newsworthy, it will not be considered unlawful. Also, if a person consents to your publishing otherwise private information about them, they generally cannot later claim you have invaded their privacy. Intrusion is the next type of invasion of privacy claim. Unlike the other categories, intrusion claims are not based on what you publish, but rather on how you obtained or gathered the information in the first place. Again, the idea is that there are certain private places that should be off limits to others, including reporters, unless a person has given you permission to be there. Bedrooms, bathrooms, locker rooms, or private office would all be common examples of a private space where a reporter could be found to have invaded someone's privacy if they went in without permission or used a secret listening device or camera to peek inside. On the other hand, other places are clearly public: a public sidewalk or street, a public park, a courtroom, and reporters generally have the right to report on or photograph anything that happens in such places. Other places fall somewhere in the middle, and it is sometimes left to a court to decide how public or private the space is. The key question in such cases: does the person in such a place have a reasonable expectation of privacy? If not, there can be no successful claim. Newsworthiness and consent are also the primary defenses to an intrusion claim. Though in obtaining consent to enter an otherwise private space, it is important to make sure the person giving consent has the authority to do so. It's also important not to lie or misrepresent oneself in order to obtain consent. The third category of invasion of privacy claims is known as false light. Not all states recognize a false light claim because, in many ways, it simply duplicates a libel claim in that the harm occurs when you publish words or images about an individual that portrays him as something he is not. A common example would be publishing an extremely misleading photo caption. For instance, a photo caption that states or clearly implies that an onlooker at a Ku Klux Klan rally is a participant would certainly put them in a false light. Other common mistakes include carelessly using an old file photo to illustrate a story in a way that falsely suggests a person is currently engaged in unflattering conduct, or publishing a fake letter to the editor that attributes opinions to an individual that he does not hold. The final category of invasion of privacy claims is also the easiest to identify and avoid. You can get in trouble for misappropriation when you use another person's name, image, voice, or other likeness to help sell something without their permission. The main hotspot here is, of course, advertising and commercial endorsements. If you want to use a picture of someone or their name, voice, or anything else that is identified with them in an ad to help you sell something, you first have to get their permission. It's as simple as that. It doesn't make any difference whether the person is famous or not. Everyone has the right to control how their image is used when it comes to advertising and endorsements. It should be a standard practice to obtain a signed model release form before creating and publishing any ad that pictures identifiable people. If the subject is a minor and money is involved, you should also obtain permission from the minor's parent or guardian. If you publish an ad created and submitted by a third party, you may want to first have them sign an agreement stating that valid permission has been obtained and that they will be responsible for reimbursing you for any claims that might result if a problem arises.